The general rule regarding the execution of wills in statutory construction provides that wills must be executed in strict accordance with the statutory requirements. This was applied in the case of Tampoy with regard to Alvarez-Tino. Here are the facts of the case.
On November 19, 1939, Petronila Tampoy, a widow without children, requested Bonifacio Mendoza to read the testament and explain its contents to her in her house in San Miguel Street, Municipality of Argao, which she did in the presence of 3 instrumental witnesses. After confirming the contents of the testament, she requested Bonifacio Mendoza to write her name at the foot of the testament in the second page, which she did, after which she stamped her thumb mark between her name and surname in the presence of all 3 witnesses. The testament was executed freely and spontaneously, and on February 22, 1957, the testator died in her house in Argao. On March 7, 1957, or 2 weeks after, Diosdado Alvarez-Tino initiated a probate on the document purportedly to be the last will and testament of Petronila Tampoy. The trial court denied the petition on the ground that the left-hand margin, as stated earlier, of the first page of the will does not bear the thumb mark of the testatrix. Petitioner appealed from this ruling. The Court of Appeals elevated the case to the Supreme Court because it involves a pure question of law. The issue at hand, therefore, is whether the absence of the testator's thumb mark in the first page is fatal to render the will void. The court held that statutes prescribing the formalities to be observed in the execution of wills are very strictly construed. A will must be executed in accordance with the statutory requirements, otherwise it is entirely void. In the present case, the contention of the petition for probate is unopposed, and that the 3 witnesses testified and manifested to the court that the document expresses the true and voluntary will of the deceased cannot be sustained, as it runs counter to the express provisions of the law. Since the will suffers the fatal defect as it does not bear the thumb mark of the testatrix in the first page, even if it bears the signature of the 3 instrumental witnesses, the same fails to comply with the law and therefore cannot be admitted to probate. The Supreme Court affirmed the appealed order without pronouncement to the costs.
Similar to the case mentioned earlier, the case of Oikukwe versus Shoka requires that the execution of wills must be in strict compliance with what is required by the law. The facts are as follows. This case is an appeal from the order of the Court of First Instance of Samar admitting a will to probate. The validity of the will is attacked on the ground that the testatrix was mentally incapacitated and that the will was not executed in the form prescribed by Section 618 of the Code of Civil Procedure, as amended by Act No. 2645. The issue involving the mental capacity of the testatrix cannot be resolved because the transcript of the testimony taken in the probate proceedings did not appear in the record. The second ground was raised apparently because of the non-compliance of the last 2 out of 5 requisites required by Section 618. It is the failure to state in the attestation clause the number of sheets or pages used in the will, and to show that the testator and the witnesses signed in the presence of each other. The issue is whether or not the omission of certain formalities in the execution of the will are fatal to its validity. The court held a will should not be probated in its execution. There has been strict compliance with all the requisites prescribed in Section 618 of the Code of Civil Procedure. The intent of the legislature is clear that these requirements have a purpose. The purpose of the numbering of the sheets is to avoid tampering, changing, or forging the documents, and the purpose that the attestation clause must state that the witnesses and the testator sign in each other's presence is to have a concrete written evidence as opposed to the unreliable oral evidence. The court ruled that the 2 defects renders the will null and void and cannot be admitted to probate.
While the old adage dura lex sed lex finds apt application in many other legal cases, in the adoption of children, however, this should be softened so as to apply the law with less severity and with compassion and more understanding for adoption is made for the benefit of the unfortunate children, particularly those who are born out of wedlock. This is illustrated in the case of Duncan versus the Court of First Instance.
Sometime in May 1967, a 3-year-old baby was given by attorney Corazon de Leon Velasquez to Robin Francis Radley Duncan and his wife Maria Lucy Christensen for adoption. The child was later on baptized with the aforementioned spouses appearing in the records as parents. Attorney Velasquez, on the other hand, received the infant from the child's unwed mother, who told the former to look for a suitable couple who will adopt the child. The mother did not provide for the maintenance and support of her child, and she further asked not to reveal her identity. In the petition for adoption, attorney Velasquez, as the de facto guardian or loco parentis of the child, gave the written consent required by law. The regional trial court dismissed the petition on the ground that the consent given is improper and falls short of the express requirements of Article 340 of the Civil Code. Such law is couched in mandatory terms by the word shall and therefore be necessary, and it enumerates the persons who will give consent to the adoption in the order as follows: parents, guardian, or the person in charge of the person to be adopted. The issue of the case is whether or not the person who gave the consent for adoption, which in this case is attorney Corazon de Leon Velasquez, is the proper person required by law to give such consent. The Supreme Court reversed the trial court's dismissal order, holding that the child's unidentified mother can be declared as having abandoned the child, so there is no more legal need to require her written consent. And the consent given by the de facto guardian who exercised patria potestas over the abandoned child was sufficient. The regional trial court in its decision had sought refuge in the ancient Roman legal maxim dura lex sed lex to cleanse its hand on the hard and harsh decision it rendered. All efforts or acts designed to provide homes, love, care, and education for children born out of wedlock who may become serious social problems should be given the widest attitude of sympathy, encouragement, and assistance. The Supreme Court further held that the law is not and should not be made an instrument to impede the achievement of a salutary, humane policy. As often as is legally and lawfully possible, their texts and intendments should be construed so as to give all the chances for human life to exist with modicum promise of a useful and constructive existence. The herein petitioners, the spouses Robin Francis Radley Duncan and Maria Lucy Christensen, appear to be qualified to adopt the child, and there is no showing that they suffer from any of the disqualifications under the law. Above all, they have all the means to provide the child with proper support, care, education, and love that a growing child needs. Therefore, the petition is hereby granted.